In addition to Medicaid planning, we also do a significant amount of estate planning throughout Florida. Estate planning is really more what you think of as the wills, the trust, the power of attorney, healthcare surrogate designations, making sure that if you become incapacitated, who can help you make decisions, and after you pass away, who gets your stuff in an efficient manner, hopefully avoiding probate court. And so with that, we are often helping people get their assets into a revocable trust or a living trust or a revocable living trust. Those are, by the way, three different terms that mean the exact same thing. There's a trust that's designed to help you, your heirs really, avoid having to go to court to get access to your assets after you've passed away. But what I wanted to address was there are some common problems with trusts that people need to know about. The first problem is when people don't adequately fund their trust. What do I mean by that? Well, when you go to an estate planning attorney such as ourselves and you are delivered a set of documents, the trust is just a stack of papers, right? You have to do something with that. And sometimes we will assist you with that. Other times people prefer to do it on their own. But essentially, you have to get assets into the trust in order for the trust to have any effect whatsoever. What do I mean by that? If you have a bank account that is in your name, what we are advising you to do, or we can help you do, is one of two things. Number one, you can change the ownership of the bank account or financial account. Instead of it being owned by you in your individual name, it can be owned by you as trustee of your revocable trust. There's lots of advantages to doing that. You get to avoid probate immediately. It's very easy for your successor trustee to take over if you become incapacitated and need help managing your money. And then, of course, when you pass away, that account isn't owned by you, it's owned by your trust. And then the trust says what happens after you pass away. Makes it a lot easier to dispose of your assets and get it to where you want to go. But if you don't rename, so one option is you rename your financial accounts individually. You got to go to each bank account, each financial account, go to your broker, and you have to change the name of the account into the name of the trust. Or as an alternative, you could name the trust as the pay on death or transfer on death beneficiary. Essentially, it would say once you pass away and someone presents your death certificate to the financial institution, they would then be obligated to transfer ownership of the account at the point of your death into the name of your revocable living trust, which is good too. If you don't do that, you can't just go to the bank and say, here's the paperwork, here's my revocable living trust, go put it in it. They're going to go, no, you got to go to court because you didn't put the asset into the name of the trust while you were alive, or you didn't name the trust as a pay on death beneficiary while you were alive. Now that you've passed away, it's too late to get assets into the trust without going to court first. And that's what we want to avoid. Same thing with real estate. And of course, if you hire us, we do this for you in terms of if we are creating a revocable trust, we're going to strongly advise you allow us to also create a deed, deeding your real estate, whether it's your homestead or whether it's a second property or a rental property, out of your name individually into the name of your trust for the same purpose. Now, some people get concerned because they're worried about the tax implications or losing homestead status. And the way we design our trust, if it is your homestead and you are living there, you do not lose your homestead exemption. It can still be your homestead even if the property is in the name of a trust, not in your individual name. So that's really what we want to be wary of. The other mistake that people make when utilizing a revocable trust is they think it provides a measure of asset protection for themselves. The reality is that is just not true. If you have your assets in a revocable living trust, because it's revocable, because you can revoke it, because you can amend it at any time, it does nothing for you in terms of protecting those assets from creditors. If you're interested in creditor protection, or protecting your assets in a long-term care context, we then, instead of talking about a revocable living trust, we have to talk about an irrevocable trust, which is the subject for another video. But your revocable trust provides you, the grantor, the creator of the trust, with really no asset protection whatsoever. Now, it provides your heirs with asset protection if the trust is constructed properly and if that's your purpose, meaning when you pass away and your kids or your nephews or whoever it is you want to inherit your stuff, if it stays in the trust upon your passing for their benefit, creditors can't touch it, again, if it's drafted properly. So it can provide creditor protection for your heirs, but a very common misconception is if you utilize a revocable living trust, it does not provide creditor protection. It is not an exempt asset for Medicaid planning purposes. If it is in a revocable trust, it is as if it is in your name individually. So for example, your homestead, if it's in a revocable living trust, remains your homestead and it remains creditor protected because it's your homestead, not because it's in a revocable living trust. So I wanted to emphasize those 2 points. Number one, common problems. One common problem is people don't fund the trust properly. The other is a big misconception, which is they think that they are now protected from creditors. So I hope I educated you a little bit. If you'd like to talk about estate planning, whether it's in a probate avoidance context or an asset protection context, please give us a call. Happy to set up time to talk to you. We serve the entire state of Florida. Thank you very much. I appreciate your time.